When someone lives there, that's when you get the claims of, I work 24 hours a day, 7 days a week for 4 years. And if that's true, and if you don't have proper protections in place, which I'll get to in a second, you could easily run up to $1 million in fines and unpaid wages.
Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
And welcome to Absolute Trust Talk, our podcast here at Absolute Trust Council. I'm Kirsten Howe, your host. Today, we are going to be talking about hiring in-home caregivers. As the baby boom generation ages, we are seeing among our clients a lot more of them needing assistance with some aspects of their daily lives. And studies show, and I'm sure most of you would agree with this, that almost universally, people would rather stay in their own homes as they age rather than move into a facility. So what that means is that a lot of our clients are hiring in-home caregivers. And there's a couple of ways that you can do this. You can work with an agency that provides the caregiver for you. But for some of our clients, it does make sense to hire the caregiver directly. And that might be because they know somebody who they think would be good for the job. It might be that they can hire someone directly for less money. There are a variety of reasons why someone might want to do this. The reason we're talking today is that a lot of people don't know that when you hire a caregiver directly to come into your home and help you, you have become that person's employer. And now you have to comply with a bunch of legal requirements that apply to the employer-employee relationship. My guest today, Jon Babillon with Fervor Law, is going to explain those requirements to us and just kind of give us some best practices so that we can avoid making mistakes that might cost us money and aggravation. I'm going to introduce Jon in just a minute, but first I have some housekeeping to get out of the way, as you regular viewers know. We will take questions from our live audience today. So if you're watching us live and you have a question, go ahead and type that into the comment section on Facebook. And when we get to the end of our conversation, I will read the questions and I'll ask Jon and hopefully he'll answer them. So without further ado, I'm going to introduce my guest officially. My guest today, Jon Babillon of Fervor Law, which is a professional corporation in San Ramon. Jon concentrates his practice on employment, business, and other civil litigation. He practices in a broad range of employment matters, including discrimination, harassment, wrongful termination, and wage and hour claims in state and federal courts, and also before the Labor Commission. He's not always in court, though. He's not always fighting people. He spends a lot of time providing advice and counsel to his business owner clients to keep them out of court. And he does that very successfully. For them, he can draft employee handbooks, company policies, severance agreements, and he does training on a wide variety of employment topics like sexual harassment and anti-bullying. Jon is a graduate of the University of California at Santa Barbara, and he got his law degree from Golden Gate University School of Law. And in his copious spare time, he has 2 sons, and so you know where I'm going with this. He's a coach. He coaches baseball, soccer, basketball in the Tassajara Valley Little League, Mustang Soccer League, and the YMCA, respectively. He's a busy guy. Welcome, Jon. I'm so glad to have you here. I know your time is valuable. I really appreciate you sharing a little bit of it with us today.
Yeah, thank you. I appreciate the introduction there. And yeah, at this day and age, I'm happy with COVID receding a little bit, and I'm having a lot more time to spend with my kids in the coaching arena. So my weekends are pretty spoken for.
Full up again, yeah.
Yeah, exactly. So, but as you mentioned, a lot of my time is with respect professionally with doing a lot of advice and counsel that, we'll be talking about hopefully today. But
right.
I'm very excited and happy to be here. Thank you for having me, Kirsten.
You are most welcome. I also have 2 boys. I remember those days very, very well of sitting on the bleachers. It's fun. Okay, so as I stated in the opening of the episode, when you hire a caregiver directly to come into your home and provide care, you actually are stepping into the shoes of an employer under California law, and now you have to comply with a lot of laws and regulations. Jon, you and I both, we run a law firm, so we have an understanding of the laws that apply to us, and we've got to comply with them, and we do mostly. But the typical person who needs a home caregiver might not understand all of those things. And one of the things that we're going to focus on today is the idea of the wage order. And why don't we start by talking about what is a wage order?
Sure. Yeah. And just before we get into that, this is a personal experience of mine as well. As my parents are in their 70s and they're starting to approach this age of, discussing with my brother is what are we going to do? Are we going to put them in some kind of home to be cared for? Or are we going to hire somebody to live in with them or just have somebody come over and take care of them at some point? So it's very personal need, and especially probably a lot of California individuals with, what you mentioned at the outset, the baby boomers becoming, at that age where it's an issue and the government can't take care of everybody, so to speak. So With that, the wage orders in California, they are there to essentially govern every industry or try to govern every industry in California. So there's 17 of them. And the one that we're going to be talking about today is mostly going to be wage order 5 and wage order 15. But each wage order contains a series of, for lack of a better term, laws that govern things such as when does overtime apply? When does somebody get meals and rest breaks? What's the minimum wage in the industry? And then is an employee exempt or non-exempt, and what are the guidelines for that? So the wage orders acts as a form of guidance and rules for employers, along with the California labor codes, which are very extensive. So that's what I think we'll be talking about today. Wage order 5, that one pertains to the public housekeeping. You're talking about your hospitals, your restaurants, and then 15 is more of the private residence realm.
Okay, so that's more in line with what my typical clients are looking at. They're bringing someone into their private home to work for them.
Sure. So yeah, that's wage order 15. So it says anybody that comes into a private household and the employer, the individual household owner steps into the shoes as the employer, which is why it's very important to understand these very complicated laws and what impact or liability you want to try to avoid. So the wage order 15, that's the one that parents might have to stay at their home and you want somebody to come in. You're talking about those people that are domestic care workers. It also applies to people that you have come in there, landscapers, or people that work on your house. So not just domestic care workers.
Right. That's a very interesting point. And I hope everybody here heard that. It applies to anybody that you hire to do work at your home, but specifically today we're focused on the in-home caregivers. Now, I know there's something also called a domestic worker bill of rights. What is that and how does that fit together with wage order 15?
Yeah, so it fits with wage order 15 and wage order 5, but basis of what the legislator did was, a lot of, in general in California, overtime applies to those who work over 8 hours in a workday or 40 hours in a work week. That's been the law for a long time. And what each of the wage orders is for wage order 5 and wage order 15 have is they have a definition called a personal attendant. And a personal attendant is one who primarily supervises, feeds, or dresses a child or person who, by reason of advanced age or some kind of physical or mental disability or deficiency, needs supervision. So if an individual that fits that definition, they're only taking care of a person or multiple people, mostly supervising, feeding, and dressing them, they could be titled personal attendant. And what the personal attendant definition does under the wage order says, okay, if you fit that narrow scope, then you are, quote, exempt from the wage order 5 and wage order 15, which means you won't get overtime when you work over 8 hours a day or 45 hours a work week, or you're not entitled to a meal or rest break. And so a lot of people were taking advantage of that, private homeowners or private employers that fall under wage order 5, and they're saying, oh, you're a personal attendant, we're not going to pay you overtime.
Oh, okay. And so then this domestic worker bill of rights came along to fix that.
Yeah. So that was
my guess. Yeah.
Yeah, that was passed in 2013. It was okay, we need to protect these very important individuals who are performing this very important need for everybody. And say, well, If you're domestic worker employed under that definition, then you will get overtime for anything over 9 hours in a workday or 45 hours in a work week. So that's
Okay.
the
So
mechanism.
it's a little bit different than Wage Order 15, which was 8 hours a day, 40 hours in a week. They pushed it out a little bit, but they are still at least covered and entitled to overtime.
Right. So it does give them that protection. It's like, yes, you will get overtime now, because before on a personal attendant, you'd be exempt from the wage order and you wouldn't get any overtime, just your straight wages. So now they try to give a little bit, you're going to get overtime employee if you work over 9 hours a day, but at the same time, you're not have to adhere to the strict 8 hours rule under California law.
Okay. So the important distinction there is that they have to be qualified as, am I getting this right, a personal attendant? They have to fit that definition?
Well, they only had to fit that definition if you were trying to exempt them from the wage orders.
Sure. Yeah, I understand. Okay.
Yeah.
If they fall under the definition of personal attendant, then you can apply the domestic worker Bill of Rights. If they don't, then we're back to Wage Order 15.
Well, the personal attendant's there no matter what. And so what the domestic workers Bill of Rights is doing is trying to say, yeah, even if you're a personal attendant, we're going to give you overtime if you work over 9 hours a day or 45 hours in a work week.
Okay, so if it applies, it's advantageous to the employer for someone to be considered a personal attendant. What do people have to do in order to ensure that their caregiver actually is a personal attendant under that definition?
Yeah, so what you would have to do is you have to make sure that no significant amount of work is performed for you or for the company. And significant amount of work is defined as anything that exceeds 20% of the total weekly hours work. That's for job duties that's outside of that prior definition that I gave of to supervise, feed, or dress a child or person of advanced age or disability. So if they're not feeding, but they're around the house and they're doing laundry or they're doing, general repairs around the house or upkeep, that falls outside of the personal attendant definition. And if it happens more than 20% of the time in a work week, then you need to adhere to the strict employment laws contained in the wage orders and the labor code that says you need overtime over 8 hours in a day or 40 hours in a work week. And you need to be provided with meals and rest breaks. You still need to provide meals and rest breaks for personal attendants.
Right.
Domestic workers bill doesn't eradicate that, but there's some other things that we can talk about later that addresses those issues and to be aware of.
Okay, so you, as the employer, as the person who's hiring the caregiver, you got to pay attention to how you're utilizing that person in terms of hours per day. Are you asking them to mow your lawn for you some of the time, or are they purely giving you that personal attendant work?
Yeah, and a good way to do that is to have some kind of, maybe an employment agreement, some kind of document that says you're going to be doing X, Y, Z, and hopefully it's in the supervised feed or dress categories. And there might be some light stuff on the side with the housing, but that's a good way to track that is, hey, here's your job duties in the job offer letter. Here's an employment agreement. Here's your job duties. And here's a timesheet, to track your hours of what you're performing. Oh,
okay. So yeah, that sounds like a good way to document the fact that you stayed within that 80% lane, is actually have the employee fill out a timesheet. This is what I did today. Yeah.
Yeah. Not only to do that, track the job duties, but also to track how many hours they worked in a day. And then to see, did you go over 9 hours today? Did you get, a meal break? So that's the basic reason why we want to do that. But then also there could be things in there about the duties. So unfortunately, in this specific setup, you have somebody's, by advanced age or disability, they're at home by themselves and they only have one person there. So if you're the daughter of the homeowner or the employer of the homeowner, you're not often at the job site or at the home to make sure that these things are being done.
Yeah, I imagine that can be challenging to someone who, number one, this whole thing is premised on I need help. And for them to actually have to be in control of enforcing the daily timesheet rules and all of that might be a little challenging.
Yes. Yes.
Okay, but it's important, and we're talking to an employment lawyer, so he has seen what happens when you don't keep good records like that, I'm sure.
Oh yeah, that's my first question: is do you have time records? And then the next one is, do you have payroll records that match the time records? I can't tell you how many times I've been in front of the labor commissioner in Oakland or San Francisco or in front of a judge. And that's the first requirement is, okay, where do you, as the employer, you have to maintain accurate and labor code compliant time records. Otherwise, the burden shifts to you, the employer, to prove how many hours that the employee worked. Otherwise, you're up to the credibility of each party, and that's difficult to do. And if you're in front of the labor commissioner, they often like to be pro-employee, and they fine for the employee in that situation, and you get hit with all the underlying wage that you owe, the overtime, and the penalties, and they can be quite exorbitant. So that's why we're here today. Hopefully that our conversation will let your audience reach out and figure out what they need to do to not get in front of a labor commissioner or be.
Yeah. Well, you just mentioned something sort of in passing that's it's tangentially related to what we're talking about, which is payroll records. So that's not really what we're talking about today, but that is another thing that if you hire someone directly, now you have to do payroll. You got to do withholding if that's appropriate. You've got to pay the normal taxes that we pay, Medicare, Social Security, all that stuff. You've got to do that official payroll stuff.
Absolutely. You're stepping in the shoes as the employer, and that's whether you, the homeowner that's hiring this employee, or the son or daughter of the homeowner, you are acting as the employer. And so you have to comply with these numerous labor code provisions and the wage orders that we talked about a little bit earlier. And so Labor Code 226 is one example of that. I think there's 8 or 9 different things that's required to be on a pay stub each week. And so you have to have legal entity of a name, the hours worked, the gross amount earned. So there's 8 or 9 of those. And if you don't have that, there's strict penalties. So I see a lot of those claims added on to the, hey, you didn't give me overtime, you didn't give me meals and rest breaks. So it's very important that you understand what the requirements of the payroll records require. Maybe you want to get a bookkeeper or hire a third party to provide that service for you, which would probably eliminate 90% of the hassle.
Yeah.
But that would be quite expensive too. And not only that, with the payroll records, in California under Labor Code 558.1, you could be sued as an individual, even though you might set up an LLC or a corporation to run this company. You could be sued as an individual if you're the one that's directing the payroll provider or directing how a domestic care worker is being paid. So,
right. They take that payroll obligation very, very seriously. You can't really get out from under that by incorporating.
Yes.
You are on the hook for that.
And everybody's very surprised about, I incorporated, I thought, and that might protect you a little bit from premises liability or personal injury.
Right.
Which is also a good thing to have commercial general liability insurance. But, as an employer, you got to get workers' compensation insurance for the employee. I recommend getting employment practices liability insurance, more commonly referred to as EPLI. So if there's a harassment claim, or if you get the wage and hour endorsement to EPLI, then if somebody sues you or the company for failure to pay overtime or wages, that hopefully you get your carrier will pick up and you'll have coverage on that sort of thing.
So you mentioned that there are financial consequences to not keeping good records, not having things as they should, not paying the overtime that you're supposed to pay. So a judge could order you to go backwards and pay all that overtime that you should have paid?
Yes, and it's not just a couple weeks or a year. Under the labor code sections, that's outside of the wage orders. The wage orders does talk about this as well, but the labor code sections are very clear that the statute of limitations for failure to pay wages or overtime or meal and rest breaks, those are 3 years.
Oh, wow.
Yeah.
That'd be a lot.
That could be a ton of liability. And then if the attorney or the plaintiff on the other side adds what's called a Business and Professions Code 17200 claim for, that could extend it to 4 years for overtime and unpaid wages. Meals and rest breaks at this point are still 3 years, but if you have a B&P 17200 claim, it would be 4 years of unpaid wages or overtime.
Okay. Now, you just mentioned meals and rest breaks. So these in-home caregivers are entitled, just like other employees, to have a meal break. What's the requirement there?
Yeah, that's exactly right. Just like any other California employee, after 5 hours worked, they're entitled to at least a 30-minute uninterrupted meal break. And then after 10 hours, if they work 10 hours in a workday, they're entitled to a second meal break for 30 minutes. And in this industry, in particular, under Wage Order 15, sometimes you're just hiring one person to take care of your mom or your dad.
Right.
And so that you don't really have that opportunity to just leave them and I'm going to go down, go to a restaurant for 30 minutes.
Right. You
'Cause
got to
under
stay there. Yeah.
Yeah, under the
They
state
need
guidance, you
Yeah.
have to at all times have one person in the house
Right.
to make sure somebody doesn't fall or injure themselves, perhaps.
What can you do about that other than hire another person to come in for that half hour? Is
Mhm.
there a way to avoid getting in trouble for not being able to let your employee go for a half hour?
Yeah, as you mentioned, the best would be having someone come in, like having two people work a shift. That's not always financially feasible, but that's the best option. Or have some come and just cover the lunches every day. And if you don't have that option, then the next best would be to have the employees sign what's called an on-duty meal break waiver, which means that because of the required job responsibilities, you can't physically leave the premises. So you will just have to have an on-duty meal break and you eat with the person you're taking care of and you just get compensated for that time.
Okay.
Yes, you have to write, instead of working like an 8 a.m. to 5 p.m. shift and you clock out from 12
For
o'clock
a
to
half hour.
12:30. Yeah, you're actually just going to say, I worked that whole shift and that person needs to be compensated for it because they signed an on-duty meal break waiver, there's no extra penalty or 1 hour of premium pay for not having a 30-minute uninterrupted meal break.
Okay. So for a little extra money, you can work around that problem if the employee is willing to do that.
Right. Right. They have the right under that on duty to revoke it at any time, which
Right.
kind of destroys that option. But
Right. Yeah.
one way to try to mitigate your risk on not providing a meal break for somebody that's by themselves all day with the person they're taking care of.
Yeah, and it is a challenging employment situation a lot of times, as you pointed out. You haven't hired this employee to sit there and assemble things or work on a computer program or whatever. They're attending someone who needs help and may not be able to be left alone. It's
Right.
challenging. It is challenging.
Yes.
Okay, so what other issues do our clients need to be aware of when they're hiring a live-in caregiver? I know that a lot of times people need 24-hour care or they need someone to be available around the clock. What would you say to those clients?
So when you have the live-in, that's when I see a lot of the litigation, we're in front of a judge or in front of a labor commissioner. In this industry, that's usually the case. You have an employee that's like, well, I don't have a lot of money, but I want to work there and sleep there afterwards. I'm not helping with the finances, obviously. But when someone lives there, that's when you get the claims of, I work 24 hours a day, 7 days a week for 4 years. And if that's true, and if you don't have proper protections in place, which I'll get to in a second, you could easily run up to $1 million in fines and unpaid wages. So having the live-in is very important to pay close attention to. Let's get them all the hiring documents. Let's get an employment agreement that specifies all the job duties. And for a live-in, the main requirement is they have to have, within a 24-hour work period, they have to have at least 12 hours of what's called, quote, off-duty work. So I always recommend to clients, if you can't hire multiple, 3 shifts, 8 hours a day, let's get some kind of employment agreement together. And more importantly, have them strictly adhere to it with the timesheets and checking in with the employer to make sure that they're doing what they need to do. So they still need to get 12 hours of off-duty work per day. And so sometimes maybe the son or daughter comes in at night and stays there just while the employee works during the day for a 12-hour shift.
Yeah, and that arrangement can work nicely because, these caregiver jobs are not highly compensated, and we live in an area that is very expensive. And so having somebody providing basically a place to live as well as a job can really help somebody to be able to do that job rather than having to commute to some less expensive area.
Yeah. So a lot of them are just people that have just come to the country and they just don't have a lot of means to pay for themselves separately. We see a lot of married couples that will take care of an employee. Again, make sure that both are hired correctly, or that it's only one person's doing the work through an employment agreement. Because I have seen allegations and claims where the spouse of the person that was hired then was asked to help in at 2 a.m, and then we got a claim from both of them that they weren't paid overtime for a couple hours of getting up at night.
Yeah, it can be tricky. I don't want to abuse your generosity with your time, so I'm going to turn to our question area and read you a couple of questions.
Great.
Aside from these employment law issues, are there other things the employer has to do when hiring a caregiver? Oh, I think we covered this a little bit, such as tax withholding and tax payment. Do you want to elaborate at all on that?
Sure. I would say the best practice is to get with a bookkeeper or CPA, and they can walk you through of, okay, this is what's going to require from a financial perspective. You're the employer, you're going to have to issue a W-2, this is how we do it. They could also assist in helping up an entity, setting up a business entity to run the company. And that's a good way. So I'd say definitely reach out to an employment law attorney and reach out to some sort of bookkeeper or CPA, because they'll square you away with getting set up as a company or employer and what requirements you have. And then also in connection with that is, let's talk to somebody that does insurance for companies. So any employment law attorney or CPA, they probably have referrals for you. But getting the workers' comp set up, that's required as an employer, would be number one. And then talking to a broker and giving you additional information of, you need a CGL policy, commercial general liability policy, and an employment practices liability insurance policy.
Okay.
That's what you need to do, get squared away right away.
Yeah, you want that protection. Yeah. Okay. Here's a good question. Do all of these rules and regulations and requirements that we've been talking about apply when you're hiring a family member to be your caregiver?
Yeah. So luckily or thankfully, at least the legislator gives us a little bit to work with on that one. The wage order is exempt or does not apply to any individual who is the parent, spouse, child, or legally adopted child of the employer. So in a lot of situations, maybe the daughter or the son is taking care of their advanced parent. And then afterwards, like, I never got compensated for this, and I spent years with this individual.
Right.
I see it all the time. I should get paid wages and overtime. Well, wage order says no. You're a family member. You're not going to get paid. It's not required for you to get paid. But if you have an aunt or an uncle or a cousin take care of maybe your mom or dad, well, they need to be treated like any other employee.
Okay.
And that has, I'm sure, it's more of your realm, Kirsten, where you have someone dies afterwards and they want a chunk of the estate, and that's a whole separate can of worms that are opened up. So you have to be very careful.
Yeah. So you can pay a son or a daughter to be a caregiver if you want to. You can arrange that, but you don't have to. The law doesn't require that you do that. And if you don't agree to do that, they can't turn around and say, hey, you owe me all these back wages.
Yeah. They can, as you know, anybody can try to sue anybody for anything.
Right.
I've had children sue their parents before, and so I'm very aware of that law. And then we have to do some kind of judicial proceeding to get that dismissed. But that's one way the parent is protected in that situation.
Okay. The parent and the estate of the parent, because a lot of times this, as you said, is the kind of thing that comes out after the parent has died.
Yes.
And, now it's a battle among the siblings.
Yes.
Which is always fun. Okay, I have one more question. What are the most common problems that you see clients having to address when they hire in-home caregivers?
Just probably figuring out, what do I do? First, discovering that they're shocked that they actually are an employer in this situation, and find out what payroll taxes are and payroll deductions. That's probably the most surprising. And then getting up to speed with, here are the employment laws. Everybody most likely has worked in California, so they understand, if they're a non-exempt employee, what overtime is.
Right.
If they happen to be an exempt employee in their day-to-day work, where they receive a salary, they never got overtime. So that in that respect, might not be overtime.
They're not as familiar.
Yeah. And these workers under wage order 5 and 15, there are exemptions, putting people on salary and not getting overtime or meal and rest breaks, for example. But the people that are taken care of, maybe your mom or dad or brother, they're going to be non-exempt. And so that means they need to be paid hourly.
Right.
So that's the biggest thing, is just getting everybody up to speed with, hey, you are now an employer. This is what the requirements are. Or you could risk it. Like many of my clients, unfortunately, find out, they get sued and they come to me and like, oh no, I had to give them all these documents and what's paid sick leave and
I know. Yeah, they find out after the fact. what
Yes.
they should have been doing all along. I know that probably people hire directly because they think it'll be cheaper. Because when you hire through an agency, you're paying the agency as well. They have to make their money. But then when you come down to, I got to pay for all this extra insurance, I have to pay payroll taxes, I have to hire a payroll service. It might not be that much cheaper. It might not be any cheaper.
Yeah, that's the quick answer. A second potential option is California has something called in-home support services, commonly referred to as IHSS. That's
Right.
a government-run facility, and there's different requirements. You could jump on Google, find out about that. But if you're the individual that needs to be taken care of qualifies, someone usually about advanced age, and the social worker says, yeah, you meet the obligations, then you can go through that program and hire somebody through IHSS if they have a contractor list.
Right.
And someone that works for IHSS is exempt from the wage orders and it's exempt from the Domestic Bill of Rights Act.
Okay.
So in that respect, that might be a better avenue for some of people that are looking for caregivers, because that might take them out of, I got to bookkeep and do all this.
Mm-hmm.
IHSS will take care of that, and you just have to pay the amounts that IHSS sets up for you.
Right. But just to be clear, you have to be financially qualified for IHSS.
Yes, there's several different factors that you should look into further or speak to an attorney about. That. Yeah. Okay.
Jon, I want to thank you so much for being here with us. That was the last question I have for you. And I really appreciate your sharing your time and your expertise with my audience.
Oh, it was my pleasure, Kirsten. I had an absolute blast. I look forward to doing something like this again.
All right. Well, you take care. Thanks so much.
Thank you.
Okay. Thank you so much for listening today. I really appreciate you being here. I hope you enjoyed the show, and I hope you learned something that is useful to you. If you like our podcast, be sure to go to iTunes and subscribe. Just type in the word Absolute Trust Talk in the search bar and you'll find our podcast, and then you'll be able to subscribe there. And that helps us with our visibility, our SEO, and various other things that I don't really understand, but I'm told is a good thing. Besides for searching for us on iTunes, you can also find all of our previous episodes and a lot of other resources. We have guidebooks, we have reference guides, we have blog posts, we have newsletters. All of that you can find on our website, absolutetrustcouncil.com, and you can search by topics that are interesting to you. Also, make sure to catch our next episode. We'll be back in a couple of weeks, and I know you'll get a lot out of that one too. I look forward to connecting with you next time.
Thank you so much for listening today. I really appreciate you being here. I am so grateful that you're in my audience, and I hope you also learned something and enjoyed the show. If you like our podcast, be sure to go to iTunes and subscribe. You just type the words Absolute Trust Talk in the search bar on your podcast button on your phone, and our podcast will come up and you'll be able to subscribe there. That subscription helps us with our visibility online, our SEO, and all those kinds of things that I never understand, but I'm told that it's important. So in addition to searching for us on iTunes on your phone, you can also just go to our website and you'll find our podcast there. You'll also find all of our previous episodes. So you go to absolutetrustcouncil.com, click on the podcast tab on our homepage, and you'll see all the topic for all of our previous guests, and you just click on the one you want to listen to. Also, make sure to catch our next episode, which will be out in a month or so after this one, and I know you'll get a lot out of that one too. So I look forward to connecting with you next time.
Thank you for listening to Absolute Trust Talk. If you loved this episode, head on over to iTunes to subscribe and leave us a review. Don't forget to visit our website, absolutetrustcouncil.com, where you can find a host of guidebooks and other tools to help you through the estate planning and estate administration process. If you need help securing your own legacy, then put your absolute trust in us. Give us a call at 925-943-2740 or email us at info@absolutetrustcouncil.com to set up your free consultation today.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.